Good afternoon, everyone. Good evening. My name is Dwayne Quasey Wright. I serve as Assistant Professor of Higher Education Administration, as well as the Director of Diversity, Equity, and Inclusion Initiatives here at the Graduate School of Education and Human Development, which is part of the George Washington University. On behalf of our intern dean, Lionel Howard, our intern academic dean, Jennifer Clayton, our faculty, students, and staff, welcome to our first DEI event of the fall 2025. This is our What Do We Mean By series, where we get an expert to demystify an idea, a concept, and in this case, a case. Mahmoud versus Taylor was decided in last year's Supreme Court term, and there were some doozies. This might have been the doozy of doozies if it came to K through 12 policy and education. Some, say this broke the right way. Others will be completely against it. But before we judge it, we need to know what we're talking about. And to do that, we have a special guest. And the bio will not do this woman justice, but I will read it anyway. It's pretty impressive nonetheless. Professor Dara E. Purvis is a scholar of family law, sexual orientation, gender identity, feminist legal theory, and masculinities. Her recent work focuses on the constitutional rights of transgender children. In fact, Dara just won an award, a prestigious award, for her paper, Transgender Students and the First Amendment. Her work has appeared in the California Law Review, Boston Law Review, Wake Forest Law Review, Florida State Law Review, Michigan State Law Review, the Yale Journal of Law and Feminism, the Cambridge University Press, and the New York Times, just to name a few. Prior to joining Temple, Beasley School of Law, Professor Purvis was a professor at Penn State Law, my alma mater. We are. Tough game, tough game, tough game. If you don't know what I'm talking about, don't worry about it. And a visiting assistant professor at the University of Illinois College of Law. A former editor-in-chief of the Yale Law Journal. And for those that don't know law school, that's a pretty big deal. She clerked for the Honorable Judge Lynch in the Second Circuit and the Honorable Judge Fisher on the Court of Appeals for the Ninth Circuit. GW, please welcome Professor Dara E. Purvis. Dara, tell us, what do you mean by Mahmoud versus Taylor?
Well, thank you so much for having me. I'm really looking forward to this discussion. Slightly moving my windows around, and I do have a slideshow, so you don't have to stare at my face blown up on your monitor the whole time. So as advertised, I'm here to discuss Mahmoud v. Taylor, decided in the last days of this past year's Supreme Court term. And this case arose out of books being used in public schools and an argument that these books ran against the ability of parents of children in these schools to practice their religion. Now, the books in this photo are not the books in question, but more on that a little bit later. So the case was brought by parents in Maryland and Montgomery County whose children attended public schools. And there were a number of books in the schools, some of them just on bookshelves, kind of available if a child picked them up, some of them read aloud in the classroom, that the parents objected to because the books had LGBTQ characters in them. For example, the book pictured here called Uncle Bobby's Wedding. And it was a relatively small number of books across the curriculum. This text on the screen now, as well, most of the text that I'll have in my slides are excerpted from the Supreme Court's opinion. So there were 13 books running across 13 grades. And as Justice Alito, who wrote the opinion for the court, describes it, they are focusing on the books approved for students in kindergarten through fifth grade and the board's selection of these books to add into their curriculum. Now, Justice Sotomayor, who wrote a dissent in the case, gives a bit more context about how these books and why these books were added into the curriculum. So the Board of Education had reviewed all the materials used in the English language curriculum and determined that a number of different races, cultures, groups of people were not reflected in the books that students read. So they added a wide variety of books. So she mentions books that tell stories about Asian American immigrants, a series of books about the civil rights leader, John Lewis. But as part of this review, the board noted that the books taught in the English curriculum did not include any LGBTQ characters at all. So the goal in adding these 13 books was just to have some selections that had LGBTQ characters. So the parents who objected to this argued the school should not expose their children to these books, meaning the school should have to tell them in advance when the books might be read and allow the parents to say, please remove my child from the classroom while you are talking about this book. And the parents argued that not doing this, not giving them this opt-out, violated their rights under the First Amendment. Now, the First Amendment protects a variety of things, including speech, press, the right to assemble. But here we're focusing on just a portion of it, really just the bolded text on screen here, known as the Free Exercise Clause. So the state should not take actions that restrict people's rights to freely exercise their religion. Now, what it means to freely exercise your religion and what it means to restrict those rights is obviously a big question. And for the last several decades, the case that gave a framework of what free exercise meant and how we answer these questions was Employment Division versus Smith. So Al Smith, who's pictured on screen now, worked in a private drug rehabilitation organization that served a lot of Native American people who were struggling with drug addiction, alcohol addiction. Smith was Native American as well. He incorporated a lot of Native American spiritual traditions into his work. And he attended a Native ceremony that involved taking peyote, which was and is an illegal drug. He was fired by the rehab organization and was subsequently denied unemployment benefits because he lost his job due to work-related misconduct. So Smith argued that punishing him because he engaged in a religious ritual violated his free exercise rights. But the Supreme Court disagreed. And instead, in a decision by the conservative justice, Scalia, the court held that incidental burdens on religious practice from neutral, generally applicable laws or state actions does not violate free exercise rights. So the court said, yes, absolutely, the prohibition of peyote burdens your ability to exercise your religion through this ceremonial ingestion of peyote. But this law was not passed because peyote is used in Native religious ceremonies. So it wasn't targeting religion. And it's not selectively or unfairly enforced only against people who are taking peyote during religious ceremonies. So even though we recognize that descriptively, this does limit your ability to exercise your religion freely, it is not a constitutional injury. Now, I will note, I have asterisks there because in the last 5 years or so, the Supreme Court has walked this test back further and further. And there is currently a majority of justices on the Supreme Court who have said they want to reverse this case, but they don't yet agree what to replace it with. So it is still good law, but it is very clear that this doctrine is on the way out very soon. So here, the parents are saying exposing our children to these books, and these are in fact the books at issue in the case, this violates our free exercise rights. And this certainly isn't the first time that the Supreme Court has dealt with arguments that something happening in a school violates the parents' free exercise rights. So this is an excerpt from Mahmoud describing a case from the 1940s where there was a state law that required students to stand and recite the Pledge of Allegiance. The laws were passed around World War I. They quickly caused conflict with Jehovah's Witnesses. The head of the Jehovah's Witness church said, if you salute the flag, you are breaking your covenant with God. So many students who were being raised as Jehovah's Witnesses refused to salute the flag. And under this law that was being challenged, if they refused to salute the flag, they could be expelled. Their parents could then be fined, and the parents could even be sent to jail for up to 30 days. And so the parents and the families challenged this, And the Supreme Court said, yes, this is requiring students to express an affirmation of a belief. So in other words, the students weren't objecting to hearing other people say the Pledge of Allegiance. They were saying, we don't want to say these words, pledging allegiance to the United States. And the Supreme Court said they are right. It violates their free exercise rights to require that they express a belief. But there's obviously a lot of space between here is a book on a library shelf that you may or may not choose to read, and we require you to affirmatively state this belief, to seemingly adopt it yourself. And almost 20 years ago now, there was a case in this gray area with very similar facts to Mahmoud v. Taylor, heard by the First Circuit. This case did not go up to the Supreme Court. But very much like here in Mahmoud, in this case called Parker v. Hurley, parents objected to a number of books that were part of their children's curriculum. One called Who's in a Family showed pictures of a number of different families and included a family headed by two women. Another book called King and King ended with two men marrying each other. And similarly, parents of children in this school district said, this is violating our free exercise rights. And the First Circuit said, no, it is not, and drew a distinction, a meaningful difference between merely exposing a child to information that the parents disagree with for religious reasons, and requiring that a child affirm a particular normative moral statement or belief. Simply exposing the child to information that the parents say is offensive to their religious beliefs isn't indoctrination. It isn't interfering with those religious beliefs, as the First Circuit held. The parents are still free to teach whatever they believe at home. But in Mahmoud v. Taylor, the Supreme Court takes a very different approach. So first, I'd like to show you just a very small snippet of the transcript of oral argument in this case. So at the argument, a book called Pride Puppy comes up. Justice Gorsuch asks, that's the one where they're supposed to look for the leather and bondage, things like that, right? Now, I have a 6-year-old and twin 3-year-olds, so I am in the market for pre-K books, and I own Pride Puppy. So this is the page in the book that Justice Gorsuch is talking about. The book is about a family who attends a pride parade with their dog, but the dog gets excited, gets loose, runs through the pride parade. And as the dog runs through the parade, the book goes through the alphabet with a bunch of things on each page that start with the same letter. So along with leash and leaf and love and lemonade and lollipop and other L words you can see here, there's a person wearing a leather jacket. That's the leather that Gorsuch is referring to. And he got to bondage all on his own. The most that I and others can figure is he means the dog's leash, maybe. Similarly, in another, at the end of that bit of transcript I showed you, Gorsuch references a sex worker. And this is the page he means. So we have a muffin, a mustache, a map, magnifying glass, maracas, irony of all ironies, a minister holding a sign that says, love thy neighbor. And if you're wondering, where is the sex worker? He is referencing Marsha P. Johnson, specifically this sign that someone is holding with her picture. So if you aren't familiar with Marsha P. Johnson, she was a drag queen. Seems likely that today she would call herself trans, although in her lifetime, the term wasn't in widespread use. She was active in the Stonewall riots of 1969 that are one of the markers of the start of the modern gay rights movement. She worked with Sylvia Rivera to found Star House, a shelter for homeless LGBTQ youth. She was an AIDS activist. She was known as the mayor of Christopher Street because of her prominent role in the LGBTQ community in New York. And yes, she was a sex worker, possibly because as a gender nonconforming person who had dropped out of high school and earned a GED while in the military, her job options were limited. So while being a sex worker is part of her story, it is incredibly reductionist to describe her as a sex worker rather than as a civil rights pioneer, and even more reductionist and factually inaccurate to say having a picture of a famous image of her on a sign is teaching children to spot a sex worker. The book on the left, Kind Like Marcia, is another children's book that I own. And I can assure you it is very easy to describe Marsha P. Johnson to a child without describing her as a sex worker. So here's another example I'll show you of how the Supreme Court majority views indoctrination. So I'm going to show you two slides from another book. So try to see if you can spot the indoctrination. So this is the end of a book. And on the two men's wedding day, the air filled with cheer and laughter, for the prince and his shining knight would live happily ever after. And there they are. So Alito's problem with this, again, writing for the court, is that there are no protesters at the wedding. Those celebrating the same-sex wedding are not just family members and close friends, but the entire kingdom. This is liable to be processed by young children, he argues, as having a moral connotation, because if this same-sex marriage makes everyone happy and leads to joyous celebration by all, doesn't that mean it is a good thing? I'm sort of making light of this, but these are really disturbing statements. This is another thing that he thinks is wrong and demonstrates the indoctrination taking place, a guidance document that says that teachers could say when people are adults, they can get married. Two men who love each other can decide they want to get married. To point out the obvious, this is a statement of fact. Two men can get married after a Supreme Court case, Obergefell v. Hodges. Justice Alito also mentions a book called Born Ready, which features a trans boy. And at the kind of emotional climax of the book, Penelope, the child who the book is about, tells his mother, "I am a boy, please help me be a boy." So Alito says that this is slyly conveying a positive message about transgender medical procedures, which I think is a reach. He also writes that when Penelope says, after his mother agrees that he is a boy, that his insides feel like love, this is a moral implication that transitioning is a highly positive experience. First of all, I don't think that's a moral implication. It is a factual description of the vast majority of trans people who transition in some way and report better mental and emotional health. But more importantly, this is the full title of the book, Born Ready, the true story of a boy named Penelope. The book was written by Penelope's mother about their experiences. The words in the book are the actual words that Penelope said. The book is a factual account of one specific transgender boy's experience. But in Justice Alito's eyes, a real transgender boy and his mother describing their own lives is a moral implication that is hostile to religion. So acknowledging this boy and his existence is, in the eyes of the Supreme Court majority, hostile to religion. I will also note, for additional irony, that Justice Alito points out in the book, Penelope's brother doesn't believe that trans people can change their sex. And Alito says it implies hateful to believe that. But again, this is a true story. Penelope's older brother actually does believe that. And these are a couple excerpts from stories and both written about and by Penelope's mom, talking about how they work to respect and love one another despite their different beliefs. So the last book that I'll show you a little bit of is the only one that's discussed in great detail in the opinion, Uncle Bobby's Wedding. So Justice Alito describes this as giving this same kind of pro-marriage equality message subtly. That the book's main character, Chloe, when she learns that her Uncle Bobby is getting married, she isn't excited. And Alito writes, the book is coy about the precise reason for Chloe's question, but it's used to tee up this normative message about marriage. Now, Justice Sotomayor was so bothered by this that she includes scans of basically the entire book as an appendix to her dissent. So the book introduces Bobby as Chloe's favorite uncle. It talks about several activities that they enjoy together. And after Uncle Bobby says he's engaged, Chloe isn't coy about why she's upset. She says, I want us to keep having fun together like always. She is worried that her relationship with her uncle is going to change because he's getting married. Not because he's getting married to a man, that if he's married, he won't spend as much time with her. But again, Alito reads this with a normative gloss. If nobody objects to Uncle Bobby's engagement by telling him that it's morally wrong to marry another man, then the book is indoctrination. And it's being subtle and coy about this deliberate pro-gay messaging. So to be blunt, Justice Alito fails to understand a children's book aimed at the 2nd to 3rd grade reading level. Now, do I actually think Justice Alito can't read at the 2nd grade level? Obviously not. I do not think that. But I do think that this factual analysis illustrates a couple of things. First, the Supreme Court majority is captured by a form of homophobia that essentializes and hypersexualizes LGBTQ people. Justice Alito can't see past Uncle Bobby's choice of spouse to see the clear message about a child worrying that their relationship with an adult will change, a theme that I have seen in just a few other children's books. Worrying that an adult getting married will change your relationship with them is a very common experience for children. Uncle Bobby's Wedding happens to tell that story in the context of an uncle marrying another man, but that's not the point of the story. But if you see every mention of LGBTQ people as flaunting, as pushing sexual orientation or gender identity, rather than a person who is LGBTQ having a common human experience that lots of us share, you say these things about children's books having this coy and subtle messaging. And this different treatment of LGBTQ people really becomes clear when Justice Sotomayor contrasts the majority's description of these books with another recent case. So 3 years ago, the court decided a case called Kennedy versus Bremerton School District. And in that case, a football coach of a public high school would go out onto the 50-yard line after every football game and pray. And this became a whole ritual where all the players and the other coaches would join him on the field. And the school board eventually said, we are worried that this is feeling coercive, in the sense that students might feel like if they don't join you for this prayer, you won't give them playing time, or they will otherwise have negative consequences. So the school board said, you're obviously free to pray, but could you wait until spectators leave? Could you do it in a more private location? Could you do something other than, as soon as the game ends, march out onto the field? And the coach, after the school board started this dialogue with him, sued. And the majority of the Supreme Court held his free exercise rights were violated. And in his opinion for the court, in that case, Justice Gorsuch said, this coach is just trying to engage in a short, private, personal prayer. But again, pioneering use of audiovisual in decisions, Justice Sotomayor again added pictures in her dissent to say, here are photos of what this actually looks like. What about this is private and personal, particularly if you are one of this coach's students? So here in Mahmoud, she returns to this case, this is from her dissent, to say, if this prayer isn't coercive, how can these books possibly be coercive? This only makes sense if you see LGBTQ people as uniquely transgressive, uniquely dangerous. And this demonstrates the second point that I want to make, that the 6 justices in the majority are playing as fast and loose with facts as other political actors are. The prayer was not private or personal. these books are not requiring affirmation of a particular moral belief. The school board did not say we are adding these 13 books over 13 grades in order to encourage particular views about LGBTQ people or marriage or trans people or gender affirming care. They said these books are part of a broader project to encourage mutual tolerance, where we work together regardless of our differences, where we respect people with beliefs that are different than our own. But in the eyes of the majority, mutual tolerance and respect for different beliefs is an objective danger to the free exercise of religion. Now, certainly there are parents who say the mere acknowledgement of LGBTQ people is something that I want to shield my children from. And in the past, the answer to you don't like this thing at the public school was, well, you can send your kids to private religious school that will teach them the religious doctrine you share, as in Pierce v. Society of Sisters. The Supreme Court struck down a law that didn't allow parents to send their children to religious school. Or you can homeschool. Wisconsin v. Yoder isn't quite about homeschooling. It's really specifically about the Amish community, but said you cannot just require that children attend public school. And this last bullet point is a little bit wordier, but I do want to flag it. So this is language from Justice Thomas concurring in a case called Morse v. Frederick. So this involved a high school student who the Olympic torch was being run by the front of his high school. The school brought students outside to watch the Olympic torch run past. And as the torch comes past and news cameras are following it, he unfurled a banner that said, "Bong hits for Jesus." He got in trouble for this. He was suspended. He sued, said that this violated his free speech rights. And the majority of the Supreme Court disagreed, said this does not violate the student's free speech rights. And Justice Thomas wrote separately to say, among other things, if parents don't like the public school's choices, they can run for school board and try to change this leadership. They can send their children to private school. They can homeschool their kids. They can move to another district. And then Thomas quoted himself 2 years later in a case called Safford Unified School District versus Reading. That case involved a 13-year-old girl who was strip searched at school because another student said she had prescription strength ibuprofen. So when it was a 13-year-old being told by an assistant principal to strip down to her underwear and then pull her bra and underwear away from her body for inspection, the solution is private school. But in Mahmoud, when a child might have a book with LGBTQ characters read to them, the Supreme Court finally recognized the cost of childcare, the cost of private school, by saying, how dare anyone say people who want to shield their children from information about the world not send their children to public school. So what does all this mean in terms of legal analysis? So here is the doctrine, a very short version of it. So including the books in question in the curriculum without giving parents a chance to opt out violates the free exercise rights of the parents. I will kind of footnote, it is likely violates the free exercise rights of the parents, technically, because the question before the court was whether the parents could get a preliminary injunction, an order from a court saying, school district, you have to notify them if these books are going to be read, and you have to allow them to pull their children out of the classroom. So the court says that Employment Division v. Smith, the case I started with, does not apply. Instead, the court says, well, these books are hostile to parents' religious beliefs. And when this hostility to religious beliefs exists, the school can only make children read these books if doing so is necessary to achieve a compelling state interest, a constitutional test known as strict scrutiny. And strict scrutiny is known as strict in theory, fatal in fact, because it is extremely difficult for the state to show that any given measure is required to achieve a goal that the court agrees is compelling. So what does this mean in practice? As the court specifically directs, the clearest, most immediate conclusion is that parents have a right to pull children out of a class if materials are being discussed that the parents believe are hostile to their religion, that they believe communicates a message that conflicts with their religious beliefs. So they get to pull their kids out of class. This does not mean that the school can't have the books or that the school can't continue to include the books in its curriculum. But the question is, what is it going to look like for schools that do want to keep these books? There are obviously huge administrability concerns. How do you predict what books might offend parents in your district? How do you notify parents about those books and ask, do you want your children removed from the classroom? If parents say, yes, I do want my kid removed, how do you remove the children? What staffing, what spaces do you need to do this? There are obviously significant costs and administrative burdens associated with this, added to the workload of administrators and teachers who are overburdened as it is. So what I suspect will be the biggest impact is what in other contexts we would call chilling speech. If you are a risk-averse school administrator or school board member, you're worried about parent complaints, you're trying to anticipate and manage parent complaints. Do you fight to keep Uncle Bobby's wedding in the curriculum, or do you just pull it? The decision gives cover, gives seemingly value-neutral reasons for school boards and school administrators to say, we have to ban these books. Otherwise, we will potentially be violating the religious rights of parents. We will potentially be putting ourselves and the school district at legal liability. And most conceptually significantly, this changes what lower courts will see as indoctrination in future cases where parents bring similar challenges. So previously, with the First Circuit case, Parker v. Hurley, as the persuasive example of this kind of question, the court said, could a school try to indoctrinate children? Yeah, and that would be a problem if it did. But just exposing children to these ideas is not indoctrination. Mahmoud says the reverse, that the mere exposure to the idea that LGBTQ people exist, that trans people exist and are loved by their families, that gay weddings are celebrated without protesters and hate, is hostile to religious belief. It's hard to see where that ends. If mere exposure to ideas is anti-religion, you can probably imagine all sorts of other religious beliefs that might object to other kinds of stories and characters. So beyond the specific doctrine and the immediate fallout, this case signals some bigger changes. It continues a line of recent Supreme Court cases that opens the door further and further to religious beliefs impacting or determining the curriculum of public schools. It also continues a line of cases that, as a number of commentators have described it, gives religion most favored nation status, that any accommodation available for any group or any benefit available to any group must be given to religious groups. This has been particularly present in the context of education. For example, saying that a program in Maine that uses taxpayer funds to pay tuition for private schools in remote areas has to include paying tuition to religious schools that teach that being LGBTQ is sinful. Or another case from last term that where the court tied over whether Oklahoma could use public funds to support a religious charter school. The only reason that the court could deadlock is because Justice Coney Barrett was recused in that case. So it seems obvious what the court will do the next time that kind of question comes up. And perhaps most troublingly, if you say, gosh, this seems really difficult for public schools to manage, that may be the point. There is a political push to undermine public education, and this case supports that effort. If any information that parent disagrees with because of religion violates the parent's constitutional rights, it's hard to imagine science classes, civic lessons, all sorts of topics being meaningfully discussed. Now, I want to be clear, I am a cynical lawyer, and particularly in talking about these broader implications of the case, I'm kind of giving the doom and gloom version of what I worry about. But for today, the case means parents can ask to pull their children out of the classroom if materials are hostile to their religion, as the parents define it. It doesn't mean that schools have to give up teaching about tolerance and respect. It doesn't mean that schools have to stop giving LGBTQ students representation in the books they read. And to return to the photo in my first slide, it definitely doesn't mean that parents can't teach their children their own values. So the parents who sued in Mahmoud thought that letting their children see LGBTQ people is dangerous. And as I said before, I'm a parent too. This is a photo of some of the books that I read to my kids. Needless to say, I make different choices than the plaintiff parents in Mahmoud. And yes, I do attend my local school board meetings. So thank you so much for your time and attention. And I'm excited to hear your thoughts and questions.
Thank you, Professor Purvis. Wow, troubling is an understatement. But thank you for enlightening us on what's going on and the future, right? Because as you said, the opt-out quite possibly will not be limited to the facts of this case.